Welcome, everyone, to day 5 of Cyberweek. It's been an amazing week. We were just talking about how many great sessions there are. It's kind of like drinking from a fire hose, but I'm glad that all the recordings are out there because there are some. I was flying yesterday, so I missed Amy's great session with her students. So I'm going to make a point today of going back and watching that. But it's just been an embarrassment of riches, and I'm really excited about this session too. With I call her my sister from another mister, Amy, so I thank you, Amy, for doing this, and I think this is going to be a really fun conversation. So,
well, thank you, and I want you to chime in. I want Neil to chime in. I want Dominique to chime in because
we will
they
not be
also
shy.
are part of this crazy enterprise, the arbitration conversation. But most importantly, I'm thankful to you, Colin, my brother of another mother, for really getting me involved in this. It was such a great thing, and now it's going to be a book. So that's what this session is just going to give sort of a preview of the book that is being written and going into editing soon and should be out by the beginning of the year of 2024. So I want to hear from all the people who are part of this crazy thing, which include Colin and Neil and the newest edition, Dominique. So really exciting. All right. So first of all, the name of the book is going to be, and you can add comments. Please reach out if you don't like this title, because I'm still sort of, I don't know, this is what we settled on. But the arbitration conversation insights.
I like the title.
I like it. Okay, cool. And insights and wisdom from experts in the field. And Colin absolutely was instrumental in creating this. So what is it? So interestingly, I mean, in Colin, you can remember as well, I mean, it was kind of funny, right? Along comes a shutdown, and suddenly, as professors, I was teaching arbitration and suddenly had to move from in-person to online literally over the weekend, like many professors did. And I thought, man, okay, we're all stuck in our houses, and how can I make my arbitration class more interesting? And I also really do want to make it more practice-oriented, and I feel strongly on, thinking about arbitration practice and not just sort of doctrinal law.
Right.
So I thought, well, wouldn't it be fun to just interview a bunch of people and click Zoom, click record, and there you go, right? And if you remember, Colin, when we were joking around about the title.
Right. Well, we tried a bunch of different things, right? The Arbitable, there was lots of things we discussed, but I like arbitration conversation. I think
me too. And we, for a minute, we wanted Arbitration Nation, but found it was already taken.
Yeah.
And we even toyed with Arbitration Croatian, but thought maybe that wasn't very good.
Well, we thought that would be good if you were interviewing Croatians.
Yeah, exactly. But, only. Yeah.
The other thing to remember is it was right at the beginning of arbitrate.com. And, Amy and I were involved, and Neil was involved since, day one with arbitrate.com. And we said, well, we want to kind of provide a forum to reflect on, where the field has come and where we are today and where we're going. And I was sort of saying to Amy, well, how can we, it's so hard to get your arms around the arbitration field. It's such a massive thing. You've got the international part, you've got domestic arbitration, there's a lot of controversial topics to address. And we're like, well, how are we going to do it? And Amy said, I'd be happy to have discussions. Let's go reach out to people. Let's just talk with people. And so we just kind of dove into it. We had no idea where it was going to go, but it just turned into a project with so much forward energy. And Amy, you carried it on your shoulders, and your relationships is what made it so rich, because everybody that you reached out to said yes.
Well, I just have a huge thank you from the bottom of my heart to all of the people that agreed to be interviewed, because that was really what made this come together. But also because, if you recall, we were also thinking about transparency and how there really isn't, right? Because arbitration is private. You don't get to hear a lot about what happens in arbitration. You don't get to hear a lot from arbitrators and arbitration experts. So I think it let us kind of peek behind the curtain a little bit and really sort of shed light on how arbitration works.
Absolutely. Absolutely.
So
and talk to people, oftentimes you hear from AAA or JAMS or the ICC, but you don't often hear from arbitrators themselves, or people who are representing parties in arbitration. So there's sort of an academic conversation about it, and then there's a practitioner conversation about it. So all right, so let's dive in, because I know you got a lot of takeaways.
Yeah, so I'll go quickly, but
I like that webisode.
100 on YouTube, and then now we've moved, and now you can listen to, I always say to my students, you can learn about arbitration literally on the run. We decided we didn't want to get dressed up, and so I like this whole web moving from the webcast to just podcasts. So
Actually,
now
there's a very, I should have done a series of slides with Amy's fashion choices over the arbitration conversation, because it's funny. There were certain, like a scarf or a shirt or a blouse, or it was like, okay, you could kind of tell this one's going to be a good one because she's got the scarf on. Yeah.
It's true, because I was wearing sweatpants otherwise. But it was fun. And so we have 100 of the webisodes, and then another, now we're already up to 16. We're recording another next week. We're recording another soon thereafter. So now we've moved into this whole new, Spotify, iTunes, you name it, anywhere you get your podcast. So right. It's really kind of moved. And so the book is really going to be kind of just crystallizing the lessons learned. It's going to come out under the ABA, the American Bar Association Publishing. So it's meant to be not sort of a, professor or doctrinal casebook, but instead to really be more conversational and to just collect lessons learned. And what I did is I went ahead and I rewatched all of the videos and listened to the podcast many times. And I tried to just crystallize and think, well, okay, what are the big themes that I can pull out of it? And so the book is really organized in terms of big themes. And I'm hoping it'll be a must-have, but we'll see what people think. But no matter what, hopefully it will be entertaining. And the big piece kind of takeaway, I think, is I add a lot in terms of OARB and online arbitration, because as you might imagine, that was the biggest game in town during that time, right?
Well, if you think what's happened since 2020, that's one of the big things. And we've really pivoted Arbitration.com, initially with Neil and now with Dominique, focusing on OARB, which of course is a term that was coined by Professor Schmitz as well. So it'd be important to footnote that. But no, I mean, I've had an opportunity to read through the book, and it's so, I mean, it really, you've made it so accessible. It's really a fun read.
Well,
it's not a
thank
dusty
you.
thing
And
you put on
Colin
the
wrote
shelf.
the prelogue, whatever you call it, the forward. You wrote the forward.
The forward. I wrote the forward. Yeah.
Yeah. So that'll be the favorite part of the book, actually.
I'm sure that's
or the appendix, which includes the protocols, because over the years, and now really into current times, just in general, now with so much of arbitration moving online, there's a lot of protocols that have come out, and so I created a chart of sort of crystallizing the takeaways. So in the preface, we talk about lemons and lemonade, and it's really about kind of how the development of online arbitration really took off during COVID. I know you talk about this a lot, Colin, with ODR in general, how COVID did more for ODR than anything anyone could have done.
Well, I talked to practitioners who for years were like, nope, can't work. Got to do it face to face. Got to have the tapping foot. Got to smell the pheromones in the room. And then the pandemic happened and they tried Zoom. They're like, well, I was wrong. Actually, this works. I like this better. So the other thing, again, is to go back to the beginning of Arbitrate.com and look at our mission statement of what we wanted to achieve, using technology, increasing diversity, creating a pathway for young people to come into arbitration. I think sometimes arbitration can be a little clubby. And as you say, it's not just confidential. It's like, it's kind of the inside. Like, how do you crack the inner ring? And I know so many people that have worked so hard to try and get in on arbitration. And I think one of the big contributions of the book is kind of demystifying it a little bit and seeing how many different people are in different parts of the field. So it doesn't feel like a fortress that you kind of have to find a door you can sneak through. It's like, no, actually there's so many different aspects of arbitration. And, so I like that.
And I hope this is only the beginning. I really hope that we do see more of the demystification, more like you and I have talked a lot about arbitration excellence. Right. And how can we sort of move the needle, because for so long, it's been so kind of clubby. So, the preface really focuses on this. How can we turn this shutdown into really lemonade, right? And I think one of the examples we have is this, how Zoom brought us together in this very cool way. I mean, honestly, I feel like I made so many friends through the interviews. And now I'm just delighted to know these people because they're just fascinating.
Well, it's what we're doing right now. Yeah.
Yeah, I mean, exactly what we're doing right now. Yeah. The other thing it really did is, so one of the main themes really in the interviews, something that, because also behind the scenes, of course, with each interview, sometimes I would have like a pre-interview meeting. So we would talk about, what do you want to talk about? And what do you think? How's arbitration going? And so during the pre-interview, and then a lot of times we would just keep talking after recording was over about arbitration. And this theme about adaptability and how arbitration can be adaptable and agile in a way that litigation just doesn't have that same freedom because of the rules of civil procedure. So I think that's a theme that really shines through a lot of the interviews. So I talk about that in the book. That was really kind of exciting because that's something I think is important with respect to arbitration, that it is. I talk about this a lot. Any student who's ever had me can say, really kind of looking at it as an adaptable process that can be in accordance with your particular context, fitting the forum to the fuss in a very, very true way, because arbitration is adaptable.
Well, I also think, if you look at the New York Convention, people start to think arbitration is one thing. This is what arbitration is. But actually, no, there are a lot of flexibility in terms of how you design arbitral processes. And in ODR, I don't talk about arbitration as much as I talk about evaluation. Because when you talk about evaluation, well, there's lots of ways to build an evaluative process. It could be Claros, it could be an AI, it could be anything, customer service rep. Whereas arbitration,
and even now,
I think,
and like ombuds or ENE, early neutral evaluation,
right,
and
evaluative mediation even,
it's pretty exciting when you think about all the different things you can do, because it is contractually designed. So adaptability was a big theme. Also, to really consider it within a larger sort of problem-solving toolbox. Colin, back to what you stated earlier, this idea that, it's exactly the same, it always follows the same process, but in reality, it doesn't, and it shouldn't. And as arbitrators, as dispute resolution neutrals, we need to think about arbitration as just another tool in the toolbox for problem solving, along with, ADR and ODR, thinking about it in terms of mixing and matching. Sometimes you might have med-arb or even arb-med. There's a lot of different processes.
Or even arb-med-arb.
Yeah, or arb-med-arb, exactly. It was really cool. I remember talking to one arbitrator about exactly that, about how it made so much sense, where she would essentially switch hats. And I know there's some controversy about switching hats between being a mediator and arbitrator, and I do talk about that in the book because not all people agree. But thinking about holistically, how can you really be a problem-solving coach? That's exciting to me. I love that. Like, that is just a really great way to think about conflict prevention and resolution.
Well, I agree with that. I also think, we in the field, we have bright lines between mediation, arbitration, all these different things. We say, well, you can't blur the lines because that means you're going to have some ethical, but that's not the way parties experience these processes. They don't want a process, they want an outcome. And if they come in and then you have all these bright lines and they don't really even understand the differences. I mean, it's amazing to me how many people, even lawyers, don't know the difference between mediation and arbitration,
No.
So I do think this kind of human-centered design approach, when we're fitting the forum to the fuss, I think we have to build a pathway that goes from where our parties are to where they want to go, which is resolution. And that may involve some mediation and some arbitration. And to be able to go on a glide path through the different stages is actually really important from a design perspective, because it doesn't,
100%.
it just gives whiplash to parties that say, well, now we're not in mediation, now we're in arbitration, well, now we're back in mediation. It's like, what are we talking about?
Yeah,
so
it doesn't matter.
I like what you're talking about in terms of building the flow.
Well, and I think I probably said this to you before, Colin, and I suppose I shouldn't say this on the record, but to some extent, I think we should close law schools and have problem-solving schools.
Yay!
Seriously, well,
you'd be out of a job though.
When when I teach lawyering and problem solving, and at Missouri they have a class that I taught for 5.5 years, and I really love that class because we look at it holistically in terms of helping people. What do you do as a lawyer? Somebody with a problem comes into your office and they need help solving their problem.
Yeah,
and that's the way to focus, right? How can we help solve problems? So that's,
I was just having this conversation with Nancy Welsh yesterday, and I really do think if you talk to parties, they don't like disputes. Disputes are a really negative thing. And a resolution, we did testing at eBay, and people thought, when we said, what do you associate with the word resolution? And they all said New Year's. It's like, oh, I'm going to lose weight, you know? So the language, mediation, arbitration, you know, conciliation, resolution, disputes, it actually alienates the people that we're trying to help. At eBay, we completely switched, as you said, to problems and solutions. You know,
I love
problems are
that.
inevitable. So people have problems. These things
Yeah,
but let's
yeah,
get a solution as quickly as we can. That really resonated. So
yeah.
I absolutely agree with you. I like the problem solving toolbox. I think
Hmm.
that is exactly the formula that the people we're trying to help resonate with.
Yep, yep. And to your point you made earlier, so I did empirical research when I was at University of Colorado, and I did qualitative and quantitative and sort of people's understanding about contract rights, but then also arbitration and mediation. And in the focus groups, you're right, when it came to they did not know the difference between mediation and arbitration,
Right.
and often thought mediation was meditation. So it really shines a light on how terminology doesn't
I
really.
actually typed into ChatGPT when I first use it. I said, what are some tips for mediation? And it gave me tips for meditation.
Yeah,
And
sit in a quiet
I said
room.
mediation. It was like, oh, I'm so sorry. I didn't realize that was what you were talking about. So
Although
yeah.
it could make, yeah. Well, and also context. So another piece, we talk a lot about fitting the form to the fuss, and of course that is very good thinking. But context, really, that was fascinating to me. And in the book, I would wish I could have kind of expanded and had a lot of separate chapters on each one, but it would have been much too long of a book, and and that wasn't really allowable under the contract. But I only have a certain number of pages, but I have 2 chapters that are really focused on all these different kind of contexts. And the thing I really learned in interviewing people is how different arbitration is in different contexts. And that was really eye-opening to show how arbitration can really take, again, with problem solving as the focus, with a functional analysis, to build a process that makes sense for your particular context. IP, employment, consumer, railroad, construction, investment, international, and more, energy disputes. I mean, there are family disputes, in fact. There are all these different contexts. Really, that was really eye-opening. I had never even thought about family arbitration until I did the arbitration conversation. And I found out that actually that's something they do in Canada and in New Zealand and in Australia. And I don't see why we don't do more of it in the US.
I totally agree. Family
Yeah,
arbitration makes absolute sense to me.
yeah, super interesting. And just the variability, and then also cultural differences when it comes to international arbitration is so important. So context was another theme that really came out, and so a chapter is devoted to that. To the point we were talking about earlier, another really in the founding of arbitrate.com, that was a conversation to improve diversity in arbitrators, such an important topic. So that was another theme that really did shine through in doing the interviews. And so a chapter is devoted to that as
Well, I'd
well.
also say, this is something, because we started, obviously Neil was essential in putting together the directory of Black arbitrators, and we had a bunch of webinars talking about this too, talking about the Ray Corollary Initiative, and I think it informed some of the arbitration conversation, because these things are happening in parallel. So
Yeah,
as more and people talk to us and we aggregate stories, we say, okay, we need to do an event on this. We need to get together not just one-on-one interviews, but we need to bring together 40, 50, 60 people to talk about it as well. So I actually think there's a lot of encouraging signs in
yeah.
arbitration that this is getting better. And as I say, the clubhouse is now, the door is open more than it used to be.
And that's another kind of an offshoot of the arbitration conversation, Colin, that was kind of cool, is along the way, we're like, hey, let's have an online symposium on this. Remember, we had one on diversity, we had one on FSASHA, we had one on recent Supreme Court decisions.
NDAs.
Yeah, NDAs. I mean, so that was kind of fun to have those kind of mini, just, hey, let's get experts together and discuss these topics.
Well, it's interesting to get people there who didn't necessarily see eye to eye.
Yeah.
And have them have conversations. I mean, the thing about individual interviews is you can hear one person's perspective, but you were really trying to get them to, you weren't challenging them in the way that a dialogue, I think, can a little bit more. And there are some controversies in arbitration, but I think that I'm proud of what we've done with diversity, and it seems like things are heading in the right direction. More work to be done.
Yeah, absolutely.
Yeah.
But also this idea of another chapter, another theme that really shined through, practice makes perfect. So what I meant there, and we really learned through all of this, especially with the move to online arbitration. For some people, it was not a very smooth transition because they had not used Zoom or Teams or any sort of an online program before. And so for some arbitrators, it was a little clunky at first. And in talking with arbitrators and in talking with arbitral organizations, I remember the very, very first interview I did, if you recall, was Svetlana Gitman with
Right.
the American
AAA.
Arbitration.
Yeah.
Yep. And she was we talked about this exact topic, you know, kind of moving people quickly and the importance of practice. You can't just assume things are going to work. And kind of doing a run through and sort of developing all of these best practices. And I thought that was really interesting. And then also kind of, for in some cases, hiring a technical assistant. That was another sort of interesting lesson learned that I had not heard of before until the arbitration conversations that I had.
Well, we talked about creating a directory of arbitration technical assistants,
Yeah.
you know, that could help out, that just handle it so the arbitrators don't have to worry about it, you
Yeah.
know, managing the Zoom and managing the documents and all that kind of stuff. So it's, you know, especially as AI, maybe AI is going to be the technical assistant moving forward.
Yeah, who knows?
Yeah.
But also even in, especially once I moved to the longer, because the podcasts are longer, so those are longer conversations. I could go into more depth. And some very seasoned arbitrators also who I'd interviewed talked about just the importance of, you know, getting practice, even if it's pro bono, right? So if you're a young individual who wants to be an arbitrator, you know, get out there, even if you're not gonna, even if it's gonna be pro bono, just getting some practice and getting some experience is so important in order to learn how to be a good arbitrator. And that's true in mediation as well. Of course, we did talk about SCOTUS because so much is always happening in the area of arbitration. And as we talked about, Colin, remember we had that little mini symposium. Neil, you were part of that as well, on sort of the recent Supreme Court decisions, because there were a lot of them in 2021, 2022. They were very active in the world of arbitration. Remember
well,
that.
and also the slow privatization of the civil justice process, right? I mean, the Supreme Court is on the record over years shifting more and more cases out of the public judicial system and into private redress. So, you know, it's kind of reading the tea leaves on where this is headed. I think, you know, we've been talking about this too, you know, with this future of arbitration project that we're starting to work on, and the 100th anniversary of the Federal Arbitration Act.
Oh, yeah.
Yeah. So,
yeah, everybody, we're making news here. Mark your calendars. We're going to have a conference on the 100
February 2025.
Yep, 2025. And it's going to be great. And Colin's going to be involved, and Arbitrate.com and Ohio State are going to team up, and it will be great. So mark your calendar for that for sure. But also the costly judicialization, another theme that really did come through that I've known about since I was in private practice, because I was an attorney representing people in arbitration at 2 different large law firms before I went to teach. And I was always struck by how the lawyers would really mess up the process by making it so expensive and filing motions and trying to do everything they do in litigation in arbitration. And so this theme came up quite a bit in terms of judicialization of arbitration, and how you really have to be careful in balancing fairness and efficiency. Now, you might, for example, you might need some discovery in order to promote fairness, but efficiency matters too. And also, you don't want to kill people with, you know, demanding documents and doing costly discovery and motion practice. And this has become a real theme. And so in quite a few of the interviews, this is another one that came up, is this idea. And how do you fight the urge to judicialize the process? I mean, unfortunately, or however you want to view it, in my view, unfortunately, attorneys, you know, sort of come at it with a background where, you know, they learned the rules of civil procedure, and they kind of are used to that type of a process. And sometimes it really does kind of go too far. And so arbitrators do play an important role in really coaching the parties and thinking through with preliminary hearings and making sure to fashion a process just to be reasonably necessary. Don't over judicialize it, but think about what are the precise procedures that are needed in this context? And how can we fight that urge to judicialize the process? Because again, what are one of the benefits of arbitration? Well, because it's not litigation, it can be more flexible. And that theme did come up quite a bit. Also, it was interesting, you know, now we see new procedures for consolidated and multi-party arbitrations. Also, there's really been this push for new procedures, as the AAA has done, for mass arbitration. And mass arbitration was another sort of interesting theme that developed during the arbitration conversation. In fact, I think it's number 97, when I interviewed Travis Lentner, who really kind of brought Amazon to its knees. Do you remember that one, Colin?
Well, that's why Amazon took the pre-dispute binding arbitration clause out of their agreement, because of Travis, because they sent it back to King County or whatever, where Neil is. So yeah, no, I mean, that was a huge get to talk to him. But you know, talking about this judicialization, obviously Tom Stepanowicz is famous for saying that arbitration is the new litigation. I just heard yesterday from an arbitration professor at A&M that mediation is the new arbitration. So, you know, the problem is these things are designed to be lightweight and streamlined, so to provide access to more people. But slowly but surely, these kind of creeping, you know, complexities get integrated because, you know, people want to introduce all their evidence, and they want to have motions, and they want to, the next thing you know, the cases, these arbitrations are taking multiple years. So I think you know, we got to keep a focus on the end users, because that doesn't necessarily benefit them. Right. The lawyers may be comfortable in that judicial context, but it's not fundamentally about the lawyers. It's more about the disputants themselves. So,
and that drives up the cost and the time, which is not good for the parties. So I think it's really essential to think about that. But also new ethical obligations. I think that we saw, of course, ICOTR, International Council on Online Dispute Resolution, came through with standards most recently in 2022, and the ABA had their guidance. And we saw really sort of new ethical obligations around the use of online arbitration. And the duty of technological competence, I think, brought on a whole new meaning. And that's under the American Bar Association Rules on Professional Conduct, Rule 1.1, Comment 8. This duty of technological competence, you know, it was kind of thrown in there and people didn't think too much about it. But now it's taken on a whole new meaning for lawyers in terms of what you need to do, and attention to privacy. So we had some really interesting conversations about privacy and cybersecurity, and of course the different protocols about OARB, online arbitration, that were developed and have just keep on expanding and developing from different groups.
Well, you collaborated with me and Ben Davis on that training early in Arbitrate.com. And I think it surfaced a lot of really interesting ethical issues. You know? And challenges if you are not competent in managing the technology, that may threaten the enforceability of eventual award, because it could be challenged on that basis. So yeah, I think it's a good point. And
that's good. I forgot about that. That was good with Ben Davis and talking about sort of what are the
we did it for Corsica, the Cairo Regional Center for International Commercial Arbitration. It was really, really interesting.
So interesting. And it really does matter for enforceability in arbitration. So it takes on a whole new meaning that's different than mediation, to be honest.
That's right.
Another thing that really, another theme that showed through the interviews, you know, given my sort of background and interest in technology, and of course, as we saw the kind of expansion of OARB and ODR, and given this is, you know, on arbitrate.com, which is Colin, and given our interest in technology, it's no surprise that a lot of interviews did look at technology. And just, you know, that ODR is not the same thing as Zoom. And I think we started to see, do you remember that, Colin, how people, well, isn't it just Zoom mediation, Zoom arbitration? Isn't that what ODR is or OARB is?
Well, and it's funny, a lot of people said, I think, I remember Mahez from the ICC saying, well, ODR, Zoom is not ODR. And I'm like, well, yeah, it is. I mean, if ODR is technology plus dispute resolution, if I do a mediation or an arbitration over Zoom, that's ODR, right? But of course, Zoom was not built for ODR. It's just another communications channel. But does picking a different channel for communication fundamentally alter the process? And I would argue, yes, it does, because, you know, but I do think it's not sufficient. Zoom is not the end state of ODR. So that's kind of the way that I would say it.
No, and I think it's so important. So examples of providers that I interviewed: Fair Claims, CREC, ODR.com, eJudicate, Really
New
some
era. Yeah, you interviewed everybody.
yeah, and it was really interesting to kind of think about smart subtle, to think about sort of, okay, let's reimagine the way we solve problems, not just kind of replicate the exact same thing we do in person, but how can we really build technology that can be more interesting, right? Instead of just replicating, but reimagining access to remedies and access to voice. And that to me is the really exciting piece when you really dive more deeply into technology and arbitration.
Mhm, mhm. Absolutely.
Which brings us to, of course, the topic of the day, the future of arbitration. And AI, data analytics, and blockchain was another theme that did emerge, and really the future of arbitration. And, we talked to people about blockchain arbitration and how blockchain technology can be used within the context of arbitration. Colin and I wrote an article on smart contracts and really sort of this use of blockchain, but then also AI and data analytics. And we talked to, of course, DRD as part of the podcast. Maybe
Debbie,
you want to
yeah.
speak a little bit to that as well, Colin, with DRD.
Well, it's interesting. If you go back to the beginning of the arbitration conversation, if you were to say to me, which of these three things are going to be bigger? Is it going to be metaverse? Is it going to be smart contracts and blockchain? Or is it going to be AI? I would have had a really hard time telling you, because all three of those things were really getting an enormous amount of investment, an enormous amount of attention. But now we know. Now we know AI is the big winner. I mean, ChatGPT, that breakthrough has changed the conversation.
Right?
And the metaverse stuff, all that money that Zuckerberg spent, he wasn't able to turn the corner. So, that may still be down the road. And then also with Sam Bankman-Fried and, the Bitcoin collapse. I mean, these things wax and wane. But right
Mhm.
now, the blockchain, smart contracts, a lot of that's just slowed to a crawl. So, it's not gone away. I mean, there's still a lot there. We spent a lot of time looking at that, and there is a real there. Those innovations can
Mhm.
be
Yeah,
disruptive down the road.
yeah.
But wow, it's all AI, man. I mean, if you look at Cyberweek, how many sessions have we done on AI?
Oh,
I'm talking about AI
yeah,
every day. It's like the big focus, not just in obviously OARB, but also in legal tech writ large.
yeah, yeah.
So, but as you say, data is the blood in the body of AI. It's all
100%.
about data. It's
Yep.
that's why companies will give you free services just to get the data out of the
Oh, yeah.
interactions, because that's more valuable to them than your money is.
Yep.
Um,
Yep. It's
I,
all
I,
about.
yeah, I noticed Facebook, obviously bowing to pressure from European regulators, has now made it so you can pay 17 euros a month and you can get a Facebook account in Europe where they won't send you any ads, they won't collect any data from you.
Yeah.
And
Yeah.
I'm like, why can't we have that in the United States? Because they don't want you to go that
No.
way. That data that
No.
they're gathering from you is more valuable than the money that you would pay in a subscription.
Right.
So I think this is the big breakthrough. And we could start a whole new arbitration conversation and just focus on AI,
A hundred
because
percent. No,
it's
I
going to be
really, yeah,
such a
yeah,
tectonic shift in
yeah,
the field. And you spend a lot of time asking people about digital arbitrators and data and all of
yeah,
that, data analytics. So it's
yeah.
exciting. It really
It
is.
is. Yeah.
Yeah.
And I think in terms of where, the interviews coming up and kind of, I think there's going to continue to be more and more about AI and use of AI. But it is kind of shocking. There's a funny meme. Have you seen this going around where
What?
it's like um blockchain is looking over at AI like very, very like a Mean Girls type thing, like very
Like,
upset that the cool kid is yeah, like, oh, everybody likes AI now and they don't care about me anymore. So, it's
I
pretty
love it.
funny. Yeah.
Yeah.
So in concluding remarks, just I'm so thankful to Colin and thankful to Neil and now Dominique working with us on this and with the arbitration conversation. I've learned so much. I just feel very like thankful and blessed that people listened, that people were willing to be interviewed and just learned so much. And I hope it's useful for students. I hope it's useful for people. It's free. It's open to the public. We don't have advertising, so we're not collecting your data, I don't think.
I don't
But
think.
yeah, but maybe they are. I don't know. But no, I
Well,
don't.
they're all on YouTube, so
Yeah,
YouTube's
it's all on
collecting the
YouTube, and
data. We're
now
not
of course
collecting the data.
Spotify and yeah. But Podbean or whatever. But I do think that I do think it's going to be an interesting kind of going forward. But again, I'd love to see what questions there are, and I wondered also if Neil wanted to chime in because you were really there from the beginning as well, and this crazy sort of idea. And I don't know if you
Absolutely.
have any
This would not
thoughts.
have happened without Neil. So
I
Neil, what are
know
your
Neil
thoughts?
is the lifeblood behind we would have these meetings and talk about all this stuff. And we always comment on each other's backgrounds as well.
We come up with these crazy ideas and we'd say, okay, Neil, go to work.
Yeah.
Neil was the one who had to make it all happen. So
Yeah.
Neil, what do you think?
Yeah, no, I mean, it's been such a long journey and such a wonderful journey. And just listening to all of you, it's taking me back to 2020, 2021, even last year and this year. And I feel like I can go on for an hour about this. But yeah, I mean, it's the experience has been so enriching because as Professor Amy was saying, oh, I have to note that I still call Amy as Professor Amy, but Colin only gets called as Colin.
I only get Colin. That's fine. I'm not a real professor anyway, so that's accurate. Yeah.
Yeah. Yes. So I mean, just looking back, the pandemic happened, and then things changed so much, and then we started Arbitrate, and really Colin and Amy were the pioneers behind it. And then I joined, and I could see every month how fast things were changing and how much information we could, collect, gather, understand, and the arbitration conversation overall is just such a rich resource to even look back and see how arbitration has evolved, not just pre-pandemic, but especially with the pandemic and after the pandemic. It just forced us all into the new technology era, and it's wonderful to look back. And now I'm thinking we should have another event about all of it. Maybe we can have multiple events where we focus on some of the core aspects of arbitration, or some core areas like consumer or employment arbitration,
right?
Or investment or international arbitration, and everything like that.
Yeah.
Well, I will say one of the things that's interesting, and Neil and I know this working at mediate.com, we've done tons of interviews at mediate.com over the years. And what happens is you do the interview and it's really interesting, but then it starts to fade because it's not new. It's like, well, that's from last month, that's from 6 months ago, that's from a year ago. But then after a couple of years, it gets really interesting again because it's like it's the first draft of history in a sense. So now we have conversations with Frank Sander, we have conversations with Roger Fisher, we have conversations with Margaret Shaw, we have conversations with people that aren't here anymore. And so I think this is going to be such a fascinating time capsule. Again, in 10 years out, maybe when we have digital arbitrators, or when OARB really has scaled, to go back and look at the arbitration conversation and see what did it look like 2020, 2021, 2022.
And think about all the legends. I mean, I was so honored. I mean, talking to Leela Love, Tom Stepanowicz, Gary Bourne, you name it, Sophie Napper. We talked to all of these experts. Remember Bobby Scott? We talked to the representative who had a new bill.
The congressman.
Yeah, Congressman Bobby Scott. I mean, that was pretty cool to have a congressman, right? That was really neat to get a chance to talk with these different individuals, but then young voices too, talking with Travis Lentner, who is very, very young, and some younger people that are really kind of doing cool things in arbitration.
Just wait until one of them becomes a Supreme Court justice. We'll go back and be like, remember that? Remember when you chatted with that? Yeah. But I couldn't agree more. Neil also, over the course of arbitration conversation, was running Arbitrate.com, putting up news items and writing articles, and really staying on top of the jurisprudence in arbitration too. So when we saw something happen, like this whole Aoife Sasha thing was really interesting, and I think we turned on a dime very quickly. It's like, wow, okay, this is a hot topic. We need to inform the conversation about this. So I thought that was an interesting dialogue too, between the field and arbitration conversation, and then back. I think there were probably people who changed some of their opinions about things based on arbitration conversations they watch, because you have an opportunity to listen to somebody that really has expertise. That certainly happened to me when I was watching these. Like, wow, I never thought about it that way.
Yeah. Well, and Neil did such a good job of sort of shining a light on, mass arbitration. If you recall, you would find, oh, hey, this latest thing, everyone is there. Remember all the arbitrations with Uber, Twitter, and sort of how these things would come up. It was really, really something, just kind of jumping on all these new issues as they arise. That was really, I think, exciting too.
Well, I want to also touch on the diversity thing again. I think when
Yeah.
we first started this project, I actually learned a lot about arbitration over the course of this. I mean, I knew about arbitration at a meta level, but really this gets down to listening to all these people who
Mhm.
have their hands on different parts of the elephant. But, you know, I didn't realize that diversity was such a pain point. And to talk to people in the field who are trying to break in and, you know, learn more about who gets these arbitrations,
Mhm.
you know, I think I'm proud of the fact that, you know, we were able to surface
Yeah.
this is a topic. It wasn't only us. Obviously, there are lots of other great organizations that are doing it, but you know, Katie Simpson and the Arbitrators of African Descent and moving that onto the Directory of Black Arbitrators. I mean, I think we made decisions about what we wanted to put our energy into based on the, you know, the priorities that we heard about from a lot of these
Mhm.
conversations.
Mhm.
So, and that we have a lot more work to do there.
Right.
Yeah.
But some really great interviews with, you know, talking with Ben Davis and Michael Green, and really it's sort of so many really great interviews that surfaced issues that we really, you know, I think I'm proud of that. You know, it really is a time capsule.
Well, it is. The other thing that's interesting is I think when I started arbitrate.com, I'm like, great, we'll talk about arbitration, you know, like, but I didn't realize there's so many different arbitrations, right? And I think that the gulf between the international arbitration field and the domestic arbitration area was really interesting. And it makes me realize there are conversations about domestic arbitration in every economy. I mean, there's got to, I mean, I don't know if there's an arbitration conversation in China talking about domestic arbitration in China, but, you know, I learned a little bit from my friend Harshit about arbitration in India. Well, it's quite a
Mhm.
bit different than arbitration in
Mhm.
the US.
Yep,
And then I think we had Guillermo who talked about
we did.
arbitration in Latin America and Mexico, and then we learned about oil and gas arbitration in the Middle
Yeah.
East too. So
Yeah.
it's very, very interesting.
And we had from Cairo, interviewed him right in the beginning, with the
That's right.
Cairo Arbitration Center,
Yep,
and in Chimdima, my student who's an arbitrator in Africa.
that's right.
And
In
we were
Nigeria.
able to talk to, of course, Merez, which she was amazing,
Yeah.
and hear about France and what's happening there. So many different arbitration conversations.
I would also say, and this has a lot to do with Lisa and, you know, the sources we got from Canada. It was very interesting to learn more about the way Canada thinks about
Mm,
arbitration.
yeah, we
Because
ended up with a lot of Canada.
there was a lot of Canadian content. Yeah. And I think, you know, it's interesting to see outside the US context, right?
Right,
I mean, you and I
right.
have been talking about these pre-dispute binding arbitration clauses for a long time and how abusive they are and what an anomaly they are in the world. But you know, I think the international perspectives on domestic arbitration, that was new for me. The international perspectives on international arbitration, I think that gets a lot more attention.
Mhm,
But
mhm.
yeah.
Yeah.
So
And
Neil,
especially the different types, that was really interesting. So I think we have a question. What do you think about standardizing online arbitration in international scale? Would that even be possible? So interestingly, great question, Domini, is, well, first of all, Colin and I both were part of UNCTRAL Working Group 3. And that went from 2012 to 2016. And the focus was to create basically uniform procedures for online dispute resolution that would end with online arbitration, which proved to be very controversial because this idea of arbitration in consumer and employment is a very much not permitted under the consumer protection rules in Europe. And so, so that was a huge sticking point. But this idea of standardizing online arbitration, I think would be really helpful and really good for individuals to some extent, but then we also do have to take into account culture and different needs and for different people, for different types of contexts. You know, I think you know, it's more than just fitting the form to the fuss. I would say it's fitting the form to the problem you're trying to solve and to the people involved, both. And so I wonder, I don't know, what do you think, Colin or Neil? Do you guys think that we could have a standardized online arbitration on an international scale?
well, you know, we did talk about the New York Convention, right? I mean,
Yeah.
and I do think like when you have a treaty instrument like that, it's like, okay, well, this is what it needs to look like. If you want to have your arbitration award enforceable around the world, it's
That's
going to
true.
follow these
Yeah.
And I think in UNCTRAL too, we spent a lot of time talking about a soft law, right? I remember the work that Vicky and Lou Del Duca were doing, you know, thinking about. So I do think it's a little bit like domain names, like domain names, we have .com and .org and .net, and that's global. And then you have .us and you have .uk, and the policies around the country domain names, the country TLDs are different than the global TLDs. But so I think there's no way you're going to get to total standardization across all economies, because the need for arbitration and the cultural norms are different. But
Yeah.
I do think that, baseline standards, and you think about like the Singapore Convention for Mediation and the New York Convention for Arbitration, achieved that sort of level of arbitration. So if you get an arbitration award in Singapore, you can enforce that in Switzerland, and they know what they're looking
Sort
at.
of, but at the same time, there's the public policy exception under the New York Convention that is used in different ways.
That's
and there's
right.
different sort of, you can tweak the rules to some extent and different. So the New York Convention is not enforced exactly the same in every place, and it doesn't have procedures as
Well,
much.
and that was the argument in UNCITRAL
Yeah.
Working Group 3,
Yeah.
is that the U.S. tried to use the New York Convention to force other countries to respect pre-dispute binding arbitration, consumer arbitration agreements, and the other economies said, no, we have the right within the New York Convention to do something to resist things that contravene our public policy. So there's always going to be an active dialogue about that. I think, I mean, this is one of the things that I've said all the way along about ODR. The judicial system doesn't work the way the internet works, whereas dispute resolution can, and arbitration can, because lex mercatoria means, you can build resolution processes that cross borders, and you don't have to worry about jurisdiction. So, I do think it's always going to be a push me, pull you in terms of standardizing arbitration. But I think we're going to see the emergence of schemes like ICANN and the domain name dispute resolution process, where you have to use OARB. Essentially, it's OARB, even though it's not enforceable in the New York Convention.
Well,
but
remember,
the evaluated system works all around the world, and everybody's subject to it, and it works seamlessly.
During the shutdown, I remember when UNCITRAL kind of brought the band back together for an online symposium, and they were talking about sort of reinvigorating the Working Group 3 ideas. And then the State Department in the US, and then some individuals, especially in South America, a lot of discussion about, okay, what if we standardized online dispute resolution, including online arbitration, just for travel industry, or just for a particular context,
right?
Like sort of limiting, and with APEC and what they're doing. So I think we're going to see
ISO.
more.
Yeah, absolutely. We're still building on the foundation that was built at UNCITRAL.
Yeah. And so that could lead to something, but yeah, I hope that people enjoy it. It's very conversational in the book. Lots of stories and just things.
Well, just give me a minute to wax poetic about Amy, because really the heart of the project was Amy. I said, this is going to be you. We're going to put you on this. We want you to be the host of every single episode. And she did it. She did it. There were no other hosts. There was no fill-in hosts for the arbitration conversation. So it's amazing to think, what are we at, 116 episodes, and you were there every single time, Amy. And I really think the reason why people said yes is because they would go watch your prior episodes, and they saw how informed you were and how curious you were. You set such a tone of welcoming, and there was never any time of putting somebody on the hot seat. And I really think that was the secret of the success. If you
and I meant it, but people did make fun of me later, and I'm sure, and I didn't mind at all taking one for the team, because sometimes I sounded really stupid, but
no, you did.
That's fine.
But
if you remember, I would be like, and
that kind of humility is why we love you. Yeah. It would be funny to go through. I mean, you watched them all again, so there were certain phrases you would use again and again over different things. So it'd be funny to do a supercut of just you saying the same phrase over and over again. And
I pretty much said, oh, we have a real treat. This is so exciting.
But you genuinely were enthusiastic about it. Yeah, that's great.
Yeah,
that's
well,
great.
Thank you, Colin. Thanks for letting me sort of infiltrate your arbitrate.com space. And thank you, Neil, for being really the brains behind the sort of our kind of silliness. So we appreciate that. And now Domini's on board, and she's going to be helping with the next iteration
with
and
podcast, right? And the next one is Joan, right? You're going to do
no, actually Tamar from Canada.
Oh, Tamar, yeah.
Yep,
okay,
next
great,
week, and then does international commercial arbitration, and then after Tamar is Joan.
Okay, I like the longer form ones. I really do. there were some times when you get into a really interesting conversation
Yeah,
and, you know, you were aiming for that 15, 20 minutes
right.
and it'd be like, okay, well, we have to wrap it up. No,
Yeah,
wait,
yeah,
wait.
yeah.
And so I think that the longer form, sometimes you can get into it.
Oh, and there's one person that I interviewed twice. Do you know who it is? Here's your quiz.
One person you interviewed twice.
Only one.
Huh.
Neil will know.
Does Neil know? I'm trying to think. I
Well,
was thinking it was
first
me,
one,
but I can't. I don't
Who?
know.
I'm thinking the first one was for the video and the second time was for the podcast, right? Yeah, but I can't remember the name. I have to look.
Who is it?
Has probably the most popular blog on securities arbitration.
Oh,
in
George
the
Friedman.
world. Yep.
Yeah,
Oh,
it
yeah.
was George Friedman. Yeah.
Yeah.
Well, he's a
Yep.
legend. Yeah.
He's a legend. Yeah, I had to interview him twice because he is so smart and knows so much.
Well, I think we went back because he was the expert to talk about
Yeah.
the issues. So we needed to, yeah. So,
Yeah. Yeah.
well, it's
Yeah.
amazing to think. I mean, George is another. It's just it's amazing what he's done.
Oh, I
Running
know.
the securities
Oh, I
arbitration
know.
blog for how
Yeah.
long has he done that? How many posts has he
Oh my
posted?
gosh.
I mean, it's
Oh, I
amazing to
know.
think you did 100 of these recorded video interviews, but just think about these people that are doing it for
Oh, I know.
20 years, you know?
Yeah.
And these are every post is like a journal article.
Oh yeah. I don't know how he does it. I mean, I don't think his securities arbitration work is just, he is really, I mean, I think he reads every single solitary case. I think he just knows his stuff backwards, forwards, frontwards, backwards. Yeah.
Wow.
Yeah.
Well,
yeah.
it is inspiring to see the people out there who are doing good work. Oh, there you go.
Yeah.
Neil put up the link. Yeah. I mean,
Yeah.
but you know, so this is it feels like the end of a journey. Now you're publishing the book. It sort of puts a bow on top of it, maybe the cherry on top of the sundae, but now we need to start a new sundae. So we'll do we're going to do another 100 arbitration conversations.
Well, and certainly, who knows, maybe I'll be interviewing a robot for one of them. That would be cool. I need to interview an AI.
Actually, we did do a book club with some guys that were writing about artificial intelligence and the law, and they were interviewed by ChatGPT. So as they talked, they scanned in the words of what they said, and they fed it to ChatGPT, and then ChatGPT would ask more questions. And the questions were really good. Yeah.
That would actually be so cool.
Yeah.
To do an arbitration.
All right. Well, let's put that on the to-do list.
Yeah. Let's figure let's make that happen, because that would be really fun.
That's great.
Hopefully it wouldn't start hallucinating. I told you when
oh, it's more fun when it hallucinates.
It is more fun when it hallucinates. And I was pretty excited though when I because Jan Martinez had told me it made stuff up about her, and so then I was like, well, let's see what it says about me. It said that I'm the advisor to the World Bank.
Wow.
I know. I was like,
the promotion. That's great. You should call up the World Bank and be like, well, I think I'm an advisor.
I know people at the World Bank are like, no.
All right. Well, Amy, thank you for doing this session. This was a lot of fun. Thank you, everybody, for joining in. Thank you, Neil, for all your hard work. And thank you, Dominique. But I think we need to jump over to the social hour now.
Yes.
So I'll put up this recording
everybody.
later today.
Oh, thanks for coming. No,
thank you, Noam. Thanks, Dan. Thanks, Ava. Thanks,
Jeff. Are you
going
to go to the social hour? Okay, I'll see you there.
Okay, we'll see you there.
Thanks, Dominique. Thanks.
All right, bye, everybody.
Thank you so much, everyone. Bye.